In this video, we return to Judge Middleton and the Whose House Is It case. If you have not yet seen part 1, it is well worth your time to watch that first. Link in the description. A lot has happened since the first hearing. The hearing resulting from the original motion to terminate tenancy is currently scheduled for May 26th. An emergency motion has been filed to allow the plaintiff to enter the property and perform routine maintenance. The motion had been scheduled, but the court was forced to close due to a tornado warning, quite to the dismay of Judge Middleton. Today we hear the emergency motion, but in the process find some unexpected rulings.
All rise.
Oh, thank you. Good morning. Come up and have a seat. And we will try to get started here. All right, are we on the record? All right, we are on the record in the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. And the case now also involves third-party defendants Mark Verpalat, Patrick Blair, and Karen Stiver. We have on the live feed Mr. James McBride and Mr. Jim Fish. Mr. McBride, how are you connected to this?
So Rosemary asked me, I'm her neighbor.
All right, that's all I need to know at this point. And Mr. Fish, how are you involved?
Your Honor, yeah, my name is Fissinger. It's just my nickname, James Fissinger. I'm also a neighbor of Mrs. Blair.
All right. We have present Mr. Matthew Hauser on behalf of Rosemary Blair. Good morning, Mr. Hauser.
Good morning, Your Honor.
And Daniel Hatch from Grand Rapids here on behalf of Joseph O'Donnell and Carla Bowers.
Good morning, Your Honor.
I'm disappointed that they're not here. I'd hope they would be, but they're here by counsel. Rosemary Blair is, are you Rosemary?
Yes, I am.
She
Your
is
Honor.
present. And are you involved in this also?
I'm Karen Stiver, yes.
All right, so Karen Stiver is present. This case is the procedurally most complicated case I've had in some time. There are all kinds of complaints and counter complaints and answers and counter answers, but it originally began as a landlord-tenant summary proceeding action, and it essentially still is. Counsel Lori Hines represented Miss Blair at that time, and she filed a petition to terminate the tenancy for this property. Street address of 11247 Lakeshore Drive, Three Rivers, a 5-bedroom, 3-bath house at Corey Lake. And here's Mr. Verpalat. It got complicated, then it got more complicated, and the court issued a stay that no one could be in the house back in January. And we had envisioned that there would be hearing on that in February. But new counsel got involved. The matter got adjourned. It got adjourned once again. It was continued from January 6th to February 1st. And the court expected that on February 1st, we would be making further ruling in the matter. Well, that didn't happen. It got adjourned and it got adjourned again. And then I scheduled a half a day for hearing in this matter for a day earlier this month in April. And March 29th. And somebody other than me, the county emergency committee, closed the courthouse that afternoon because of a feared tornado that never developed. So we squandered that half a day, and then I had a very difficult time rescheduling this in light of the court's other docket and the vacation I was on. So there are a number of other complaints and counter complaints, but there are only two matters I think that we have. It's the original case and question about lifting the stay for occupancy of the residence. I'll turn it over to the plaintiff, and then we'll hear what Mr. Hatch has to say. Mr. Hauser, what's your position?
Thank you, Your Honor. So as it relates to the originally filed motion, essence, the motion from, it's entitled Plaintiff's Motion for Relief from the January 6, 2023 no entry order, which was entered on the record during the hearing that day. At the request that we are seeking is due to the fact that this case is taking longer than we initially intended, and we're not back before this court roughly in the beginning of February, that the home simply needs to be maintained. And that it would be in both parties' best interest to ensure the home is maintained. At the time, at the January 6th hearing, Ms. Blair was ordered to ensure that all the bills were paid, utilities were kept up, and the like. The question we have, and where we don't know, is what was the state of the home before the winter months, just to ensure the heat's on, the pipes are good, and the like. As we all know, that properties need to be maintained, and that way this asset can be preserved until further order of this court. So it's a request for possession for the purpose of maintenance. There is a notice of less pendants that was filed by the defense. We're not seeking to have the property conveyed or anything like that, just to ensure this home is properly maintained. Thank you.
All right. I think everybody's in agreement that we need to lift the stay. And maybe the question is who gets to stay? Mr. Hatch, what's your position?
Morning, Your Honor. Dan Hatch on behalf of countered plaintiffs Joseph O'Donnell and Carla Bowers. May it please the court. With respect to the motion for relief from the no entry order, there's three reasons why the motion must be denied. First, Ms. Blair does not have any right to access or enter the property without my client's consent because she has failed to timely file in response to the counterclaim and is now in default, which I think is the third motion before the court here. Not really a motion, but we filed a request and then the court is compelled to enter the default upon the request. So this means that my clients, Joseph O'Donnell and Carla Bowers, are entitled to exclusive possession of the property. So the court can't lift the no entry order and allow Ms. Blair back into the property because my clients are entitled to exclusive possession under that default.
Well, I can lift the no entry order in favor of your clients.
Certainly. Yep. And that's what we're asking, Your Honor, is that.
Well, go ahead with your other two reasons.
Okay. And I can go through, I can procedurally, well, the first reason is just because my clients are entitled to possession of the property. I can go through and say why a default is proper, but it was all.
Right, well, let's set the default issue for a side. Okay. What's number two? They had a valid lease at the time?
Number two is because the request is made under MCR 2.612 for relief from an order. The court rule that governs that requires, in case law, requires extraordinary circumstances to obtain relief from an order of the court. Ms. Blair has not set forth in her motion or provided any evidentiary support of extraordinary circumstances that will justify relief from the no entry order. So in her actual motion, Ms. Blair and Mr. Hauser here represented today that properties need maintenance, but there's no, and I don't dispute that, but there's no evidence that the property is in disrepair right now or in need of immediate maintenance or anything that needs to be performed on the home.
Well, that's partially probably because of my order. I ordered everybody stay out of there, and now I think the heat is on. But so they probably felt somewhat constrained to do further inspection. But certainly, all right, go ahead. So no extraneous circumstances.
Extraordinary circumstances.
Extraordinary
is what the case law requires. There's, again, no assertion of any extraordinary circumstances and also no evidence of any extraordinary circumstances. I emailed Mr. Hauser before this hearing on March 31st, and I said, what maintenance needs to be performed? Are you aware of the properties in disrepair? And I included that in our response, the email, and he said, I don't know of anything.
Well, at this point, I don't know if the fall leaves got raked, the yard needs to be mowed, you know, the things that you do when you maintain a household are all being deferred, and we're all in regret. We didn't deal with this in February, but we need to deal with it now.
Right.
All right.
So Your Honor, you know, we obviously want to maintain the asset of the lawsuit, but the request is not to maintain the yard or to rake the leaves. The request is for Miss Blair to have unfettered access to the house. So another thing that I want to point out to the court is that in the motion, Miss Blair asserts that after October, she has no idea what the status of the house is. That's wrong. Miss Blair went out, and it was actually, I believe, in front of this court because there was a condemnation proceeding and there was a fix-it order that was required by the court. On November 16th of 2022, the township zoning officer, I believe, Mr. Coleman, confirmed that the property was repaired, it was habitable, and that was in good condition. So that's just factually inaccurate. And the bigger picture, Your Honor, is that the motion for relief is not even a veiled attempt. It's a blatant attempt to avoid the summary proceedings process. Miss Blair wants to avoid the summary proceeding action that she filed, and we have a counter action for summary proceeding, and wants to avoid our hearing now that's scheduled for May 26th, I believe, the formal hearing, and to be granted unfettered access to the property before that time. And the reason is very simple why she wants access to the property. She wants to move back in. I have through a FOIA request, which if I could approach the bench, and I'll give a copy to Mr. Hauser as well too. Can I approach the bench, Your Honor?
Yes.
Your Honor, this is an email from Lori Hines, who is Miss Blair's prior counsel, that she sent to the sheriff's department after she filed the lawsuit, and I've highlighted the relevant portions. Number one, Ms. Hines confirms that Ms. Blair has changed the locks twice, violating the anti-lockout statute, but that's for another day. But the last paragraph is the most important. Ms. Blair is hoping to restore the home to a condition she can live in full time. Until something is done about Mr. O'Donnell, she cannot move back into this property. She wants access to the property, not because there's any maintenance issues, not because she wants to maintain the asset, but because she wants to avoid the legislative enacted Summary Proceedings Act that we need to go through before the judge decides who's granted access to the property. So again, it's not an entry, or it's not a motion to lift the no entry order for maintenance. It's so that she can be granted unfettered access to the property. And finally, so again, there's no extraordinary circumstances presented. There's no evidence. We know what the real attempt for the no entry order to lift the stay of the no entry order is. And then finally, procedurally, the third reason is that with the original motion, Mr. Hauser did not file a brief in support in violation of 2.119, and therefore the motion shouldn't even be entertained in the first place. But beyond the procedural defects, obviously, my clients are entitled to possession of the property, which I think is our motion for default here today, and there's no extraordinary circumstances. So nothing further unless the court has questions.
All right, thank you. Mr. Hauser, it's your motion. I'll give you the last word on it.
Thank you, Your Honor. No, we are not seeking to circumvent the summary proceedings. We are ready to go on May 26th at 3 p.m. If the court has any questions as it relates to the current status of the property, that's what we have Mr. McBride and Mr. Fisker here before. They both have had eyes on since the time in which this motion has been filed. As it relates to the reason why the initial motion should be struck, the ability or the request for relief and the court's ability to request that relief was cited within the motion itself, and that is sufficient. We then, of course, have had the argument today over the reply brief and the responsive brief that was a separate motion, and the motion to strike filed by Attorney Hatch. So no, I mean, the request is we want the property maintained. If the court wishes to put limitations on what can and cannot be done with the property until further order, we are absolutely okay with that. we're not seeking to move back in, merely to maintain the assets so that when we figure out what we're going to do with this house, it is in a workable, safe, and habitable condition. Thank you.
Your Honor, just one more thing, not that I want the last word, but I did fail to mention something. We have 30 days until the actual evidentiary hearing
Yes.
for the termination of tenancy. There's no reason, there's no maintenance issues. Also, I'm going to object to any witness testimony here today. It's a motion, it's not an evidentiary
Well,
hearing.
they're certainly welcome to watch, but yes.
But it's not an evidentiary hearing, and it needs to be included in the motion. If they wanted to submit affidavits, they could have done that before here. But again, in the next 30 days, there's no evidence and there's no reason that Ms. Blair should be back into the house, allowed into the house, circumvent summary proceedings, and then also unfettered access to the home. There's no reason at all, Your Honor.
I would note, Mr. Verpalat, one of the third-party defendants, has also joined us, and he's here on the Zoom feed. It took me a while. I kind of, when we were at one of the first hearings, I got Ms. Hines' pleadings. I saw that email, and she was indignant that the defendants were in there and they were removing property, and she contacted the undersheriff, and I was aware tangentially of the zoning action. There were several actions going on in the summer of 2022. There was a personal protection order between Mr. O'Donnell and Mr. Verpalat in August and July. That was going on. Then there was the zoning case. And that was in the name of Rosemary Blair and the other owners of the property, not in the names of the tenants. And then that was settled. She owned the property, she accepted settlement. You indicated, Officer Kuhlman indicated that the property had been made habitable, and I have the zoning, I have the PPO file, I have the zoning file, and this file. So as we got into the hearing and I learned, and I started to hear Mr. O'Donnell's position, I was offended, maybe outraged is too strong of a word. My opinion at that point was the defendant, the plaintiff, used the zoning system to force the defendants out of the house. And I have some serious concerns about violation of the lockout law. I felt that they got used. She self-reported a zoning violation. Allegedly, there had been some damage to the deck, but the photographs showed just minor damage to the deck from apparently a tree that had fallen earlier. And then they got under the house and realized that some of the stuff was supported by bottle jacks and it may have been dangerous. So they condemned the house immediately without notice to Mr. O'Donnell and Miss Bowers. And I believe the plaintiff used that as a pretext to terminate the lease with option to purchase. Miss Bowers and Mr. O'Donnell were the lawful occupants of the property on the day that zoning enforcement action took place. The police came out there like I won't say it. Anyway, they came out there. Miss Bowers was asleep. The house was neat and clean. All the beds were made. They were using it for the purpose they had intended. And they came stomping in there, got her out of bed, kicked her out of the house, told her she couldn't stay there, and they were evicted. And I felt at that time, I haven't made a ruling yet, that it violates the lockout law. Then they changed the locks and did some other stuff. And some earlier attorney sent an extremely threatening letter saying, "Rah, rah, 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 rah."
Your Honor, those letters, if you're looking for them, are Exhibit 9 of our brief in opposition to the motion relief.
Now,
motion
they're
for
in the
relief.
original pleadings as well, but the lockout law, which is found at 600.2918. Any person is rejected and put out of any lands in a forcible and lawful manner and is afterwards being held or kept out by force is entitled to 3 times the amount of his or her actual damages, or $200,000 or $200, excuse me, whichever is greater. Paragraph 2, any tenant in possession of premises whose possessory interest has been unlawfully interfered by the owner is entitled to recover the amount of their actual damages, $200, whichever is greater. And I think there's a position in there also for attorney fees. By changing or altering the locks, this is 2F, by causing by action or omission the termination or interruption of services provided. They called the zoning people to ask them to condemn their own house. And then they used the section of the lease option to purchase that says under destruction or condemnation of the premises, if the premises are damaged or destroyed by fire or other casualty to the extent that the enjoyment of the dwelling is substantially impaired, landlord in its sole discretion may elect to repair the premises or terminate the lease upon 30 days written notice to the tenant. Well, that wasn't even done. If the premises are condemned and cannot be repaired, this lease will terminate on 20 days written notice by either party. So on the day the zoning police show up, Mr. Bowers, Miss Bowers and Mr. O'Donnell have a lease with option to purchase effective November 15th of 2021 with 0 monthly payment. However, the testimony at the earlier hearing was they had given Miss Blair $85,000 plus an additional $15,000 plus some other money. Their testimony was they were paying $200 a month, although the lease did not require that. What's really going on is this is a purchase price for $450,000, and this house is probably worth $800,000 to $900,000. A $450,000 sale price in this market for this house is a very low price. At any rate, they called the zoning police on themselves, condemned their house, immediately kicked the defendants out, attempted to change the locks, and this action was begun. Ms. Hines was indignant, and then I said, well, I'm not sure your client has clean hands. Well, then she was more indignant. I hadn't made any finding at that point, but that was my impression at the close of that hearing. And I'd seen the zoning case. I saw the very minor damage to the deck. And then it started out as this. So the lockout law could allow the defendant to claim 3 times their actual damages plus attorney fees. So it is a summary proceeding action. There's all this other stuff circling around, but it boils down to the defendants want to execute the contract, which is a specific performance action. The plaintiff contends in some of the pleadings that she wasn't competent or capable to enter into such a contract at that time. Specific performance is an equitable remedy that mostly rests in the circuit court. So that's a concern that you should have on behalf of your client, whether they violate the lockout law, and she's going to be liable for 3 times the amount of their actual damages plus their attorney fees. And the question is whether or not they can execute the contract. So she wants the house back, but they have a lease, they had a lease that was in effect at the time, and they did an end around the lease by using a zoning action. I'm not sure whose idea it was. The PPO action was going on at the same time. The zoning enforcement people also get a phone call saying they want their house inspected. Again, with zero notice to the tenants in the house. So they were out. Miss Blair, I think, has been paying the utilities. I'm not sure if anyone's mowed it or anything, but your clients aren't here. I was hopeful they would be here. What do they want?
Yeah, they want, at the end of the day, they want to consummate the transaction, which is our counterclaim for specific performance. And they also want to be made whole for their damages. Outside of the monetary damages, we have, I think, nine claims in our counterclaim, excuse me. In addition to consummating the transaction, which I have offered to sit down and try to work out with opposing counsel, but it hasn't been fruitful. They need to be made whole for the damages. Mr. O'Donnell has 5 children. So if Miss Blair claims that she was stressed by receiving the counterclaim, imagine the stress that Mr. O'Donnell had on his life and his kids' life when they were unlawfully evicted from the property, didn't have anywhere to keep his 5 kids. His relationship with Miss Bowers fizzled out after that because she was so distraught that 2 men came into the house when she was sleeping twice without warning and searched the premises, which she didn't know anything about. So it's ruined his personal life. It's really put a strain on his relationship with his children and where they're at. So at the end of the day, that's for a different hearing on the 26th, but they want to consummate the transaction. They've already provided Ms. Blair with over $100,000. And then also to be made whole for the damages that they've incurred by finding alternative housing and the attorney fees, which are very high at this point because we've had to file countless motions that I think are improper under the court rules. They're seeking to extend the time. There should be a default entered. Now there's a motion to extend the default, which is improper under the court rules. It should be a motion to set aside a default judgment, which they don't have.
Well, I haven't actually entered it yet. So.
Right. So yeah, procedurally, I guess, but the motion for extension of time will get there because it's the next motion, but the grounds aren't there and the relief can't be granted by the court. So, if they want to try to have a pass at the default under 2.603, the motion to set aside the default, they have to have a meritorious defense and good cause, which they don't have. But to answer the court's question, at the end of the day, we would like to consummate the transaction. Mr. O'Donnell would like to move back into the house that he put a lot of work into and paid over $100,000 for. And then also he wants to be made whole for his actual damages after the wrongful eviction.
There's one other thing that you failed to mention. At the time, they had given notice to Mr. O'Donnell if they wanted to execute the sale within 30 days. I don't remember I wrote it down, 90 days.
90
so
days.
He had started working with a financial lender to complete the transaction. And his testimony was, it was his intention to complete the purchase of the home.
He was ready, willing, and able within 90 days from Ms. Blair when she said, I want to move forward with the purchase price to purchase the house. After that time, I believe that was August 4th. After that time, the pretextual zoning condemnation happens. They get illegally evicted from the house. And then now she files a summary proceeding to recover possession of the property, which is ironic in itself because she already had possession of the property because she illegally evicted them from it. So, and one more thing, Your Honor, too, the lease with the opt-in to purchase, which is a land contract, that Ms. Blair now claims she didn't have the mental capacity to sign because she has lymphedema, which is swelling of your lymph nodes, not a mental capacity order, doesn't affect your cognitive ability. That's the very contract that her lawyer relied on, Mr. Yonker, to terminate under the condemnation term of that contract. So when she was illegally evicting him, she used it to kick him out. And then now that she's stuck with it because the terms aren't beneficial to her, she's saying, I didn't have the capacity to execute that contract because I was had lymphedema, and I was in pain.
Well, where I was going was the interest rates have substantially gone up. The money that Mr. O'Donnell would have been able to borrow in August of 2022 and what he has to pay interest to borrow it today, I'm sure has greatly increased. And so I'm not sure what's going on behind the scenes, but they're certainly, their position is much worse than it was at the time. And that theoretically, that contract is still in effect. Now, it's expired because of the legal action. By theory, they were supposed to complete it by, I think it was November 30th. At any rate, it has not been completed, but his testimony was, once she gave him the notice, he was ready to complete it. And then this pretext zoning action took place, which resulted in them being removed from the house. My more specific question is, what do you want me to do the next 30 days? Just leave it as it is in the status quo that neither party is in it?
No, Your Honor, just in response to the motion to lift the no entry order, we obviously want you to deny that in favor of Ms. Blair. We want you to enter the default under 2.603, because under our counterclaim, we have a claim for quiet title, which is properly before the court, and the court does have jurisdiction when it's coupled with a summary proceeding, and the summary proceeding action where we are entitled to possession of the property. So it's really the opposite. We want Mr. O'Donnell and Ms. Bowers to be able to go back into the property, and then the hearing on the 26th is the evidentiary hearing about their damages.
All right.
Oh, I'm sorry, one more thing, Your Honor, too, if I may. After they were evicted from the property, all of their personal property was removed by Ms. Blair from the property. Snowmobile, snow blower, countless items in the garage, it was all taken out of there by Ms. Blair. And that's what our conversion and statutory conversion claim pertains to.
And the problem with those items is they're all over $25,000. And where are those things?
I don't know. We made a demand for the return. We don't know because we didn't take them out of there. I do know, I did talk with Michigan State Police Officer Trooper Owen, who was involved when Miss Blair was calling, how do I say this nicely, calling a lot the Michigan State Police and trying to report Mr. O'Donnell for coming back to the house when he was locked out, saying that he was breaking into the house and trespassing in the house when he had a lease that allowed him to do that. I did speak with Trooper Owen. He will be testifying at the 26th hearing, and I think the judge recommended that at the January hearing. He did tell me that the snowblower was in some salvage yard. Mr. O'Donnell doesn't know where that's at. We've demanded all the personal property back from Miss Blair. She hasn't returned any of it.
All right. So your position is the win by default. And then the question is, what do we do with the lockout law and the other issues of damages? And they should be entitled to immediate possession.
Correct, Your Honor. Under quiet title and the Summary Proceedings Act that we have in a counterclaim, the default establishes liability. Our client is entitled to immediate possession. The hearing on the 26th, and I do understand the reason we had the allegation in our counterclaim that some of our claims, which is really our statutory conversion claim, may exceed the $25,000 limit for jurisdiction for this court, is because of the treble damages associated with that. That's the only reason that I pled arguably one of the claims is over $25,000. Now, the proper procedure for that is MCR 4.002 that says if a claim outside the district court's jurisdiction is coupled with other claims in the court's jurisdiction, that claim is bifurcated. So typically what I do is I file a motion for bifurcation, or opposing counsel would just stipulate to it. We could remove that claim to the circuit court. But this court does have jurisdiction over the summary proceeding and also the quiet title claim.
And I don't want to my preference would be to get this all the way to the finish line. I don't want to do part of it and then dump this all on the circuit court. Or at least get it in a procedural posture that, because it's really going to delay things then. Transcripts will need to be prepared. It's going to take a year or more to resolve it if it's removed to circuit court. All right, Mr. Hauser, your response?
So I guess, I mean, the question here all comes down to how much money was paid. I mean, through our pleadings, there's we stipulated to around $30,000, give or take, was paid to Ms. Blair. There's a question over when that money was paid and then how much, because I know there's now what, 120,000 based off the transcript from last time.
That was her testimony, that they had paid her $85,000 at the front end, another $15,000, and then they had paid $2,000 a month for a number of the months, even though the contract called for zero. She needed the money and they were paying her $2,000. That was their testimony. So they contend they gave her 120,000 approximately dollars.
Yes, and it is.
And her contention, it was only 30,000?
Yes.
Okay.
There's a question over this promissory note for the 85,000. I think when those two numbers are added up, we get to about that 120. As it relates to the motion now, you know, we still would request the ability to maintain the property, the lease itself, the option to purchase has not been executed. To the best of my knowledge, at no time did the defendants contact Ms. Blair after there was contact to begin that closing process with cash in hand ready to close.
Well, they had a time frame. Their testimony was they were working with a lender in New Buffalo or somewhere. I mean, this house is a bargain at $450,000, and they wanted to complete the purchase. So I'll take them at their word that they were attempting to get the money to close it before whatever the deadline was going to be. All right. Yeah. Anything further?
No, I was going to say that by the end of 2022, whether or not the defendants were working on financing or not working on financing, that issue set for a different day. Financing did not appear to have been secured. Funds were not transferred to Ms. Blair. So until we figure out if we're going to allow for that lease with option purchase to have a future set date to allow defendants more time or the like, the property still needs to be maintained, and that remains the position of Ms. Blair.
All right, thank you. I'm going to grant the relief you're asking for. This was we'll call it lease option to purchase or land contract. The defendants were in there under a lease. The plaintiff used the condemnation section to kick them out. And then it says, landlord may in its sole discretion elect to repair the premises or terminate the lease upon 30 days written notice to the tenant. I don't believe that's ever been done. If the premises are condemned or cannot be repaired, which they can be, this lease will terminate upon 20 days written notice by either party. Neither of those have been done. The defendant is entitled to possession of the premises under his lease. Now, the lease is expired, which is problematic, but they're entitled to possession of the property until further order of the court. I have some serious concerns about whether this violates the lockout statute, but just as a practical matter, the plaintiff is not entitled to terminate their tenancy based on violations of the lease. They didn't follow their own rules. Now, maybe it's in that letter from Mr. Juncker. that there was a 30-day notice. Let me see if I can find it. Yonkers. Yes, was exercising your option to terminate and give you 20 days notice. Mr. Blorm, Ms. Blair informs us you responded to this notice by abandoning the property. That's not, none of that's exactly accurate. So I find that the defendant is entitled to the premises of the property, and I will grant your entry of default. Damages are gonna be substantial. The attorney fees, the meter is just ticking. There are other issues about loss of the things that you mentioned, loss of the ability to execute on the thing, change in interest rates, having to find other housing, loss of personal property. This case needs to be settled, but if it isn't, it's gonna be very expensive. Anyway, I find that the defendant has possession of the premises and shall immediately have all utilities put in their name and pay the same. I will order that the defendants pay in escrow to the court $2,000 per month. Starting May 1st. And defendant's motion for entry of default is granted. That certainly doesn't resolve all of the issues in this case, but it gets us somewhere. We're still struggling with how to order specific performance of this contract. And what do we use for deadlines? And does district court have the authority to order specific performance? And there's the underlying issue. The defendant contends she wasn't competent to enter into such a contract. But as you point out, she uses it as a sword while asking to use it as a shield. So, Mr. Hatch, I'd ask you to prepare an order to that effect. Our next hearing, I had a very difficult time finding room to put this. I had blocked out that entire afternoon and I apologize. All my jury days were scheduled. We had a vacation. I have several other large cases that take a block of time, and we have the judicial conference where we're gone 2 days in May. So I've blocked out 2 hours. Let's look at that date. I may be able to move it ahead.
Your Honor, if I may just clarify the order, just so I don't get it wrong. Number one, I can submit it under the 7-day rule, if the court would like.
That's sufficient.
Okay, and then defendant is entitled to immediate possession of the property. Defendants, Joe O'Donnell and Rosemary Blair. Joe O'Donnell and Rosemary Blair will immediately put the utilities in their name. They will pay escrow proactively, not retroactively to the court, of $2,000 a month starting on May 1st of 2023. And that our motion for default with respect to our counterclaim is granted in its entirety.
Correct.
Okay, thank you, Your Honor. Oh, and then also logistically, Your Honor, I believe that the locks are still in the house. So could we have something in order that Ms. Blair will facilitate the unlocking of the property?
Yes.
Your Honor, and if I may, as it relates to the default, I guess just for the record, I haven't prepared. It will be filed with clerks clerk's office when we get out, we're to finish today, the motion and affidavit to set aside the default.
All right, so now that it's entered, I guess you can move to set it aside.
Yes, it
And-
was previously filed with this court on or about April 5th.
Well, I tried to parse out all the pleadings and then I had it all well organized before we canceled the day in court. Then I went on vacation. Then a bunch of more pleadings came in while I was gone. So I spent a number of hours this week trying to parse this all out once again and look at the new pleadings, but all right, we'll address that. Friday, May 26th is a landlord tenant date. Let's move that hearing up to 3 o'clock. Excuse me, 2 o'clock. That will give us an additional hour. We'll do a new notice.
Judge, just logistically thinking here, if plaintiff is going to file a motion to set aside the default, I don't know if that's going to extend beyond the period for my response for the hearing on the 26th. So,
Let's see what we can accomplish on the 26th. I don't want to lose that date.
okay,
And if we have to set further hearing, we'll do that.
thank you.
But we'll move it up ahead to 2 o'clock. It's a landlord tenant day and it always gets very full. I have the morning full and I have, I'll need some of the afternoon, but we'll start at 2. You're certainly encouraged to continue to discuss this and see if some settlement can be reached. The longer this goes on, the more expensive it's going to get for everybody involved. The defendants want to buy the house. Ms. Blair at this point doesn't want to sell it. But I've ruled at this juncture that the motion to terminate the tenancy is denied. And there's a substantial risk of finding a violation of the lockout law. All right, is there anything further we should place on the record here?
Just, I think you dealt with this with the motion of entering the default, but plaintiff did have a motion for an extension of time, and I assume that that is denied.
Yes.
Okay, and would you like to prepare a 7-day order with respect
Yes.
to that? And then we do have a motion to strike the reply, but I think that is now moot at this point. You know, I would just ask for future reference. For non-dispositive motions, reply briefs are not allowed. The court rules matter. So certainly for dispositive motions, if we get there, but you know, we just get in this endless battle of
Procedure.
reply.
Well, I'm trying to
Sure.
focus on substance rather than procedure, and there certainly is substance here. There are real people with real issues. There's a lot of money at stake. There's heartache and anguish on each side of the equation, and that's substance, not whether somebody hit MRE 404BC1. That's my license plate number. Anyway, there's real people with real issues. You've got competent counsel on each side, but I do believe that the process was abused and they were unlawfully put out of this house. All right, we'll have more to do beginning at 2 o'clock on May 26th.
Thank you, Your Honor.
Your Honor, just if I may, is that the date and time set for the motion to set aside the default as well? Or will
You
it
might
be
as
different
well
date?
notice it for that same date,
Okay.
but he may not have time to answer it. So we'll address it, but we may not be able to come to a conclusion on it. But I don't want to squander that date because this order's got a 7-day order. You're going to file that. But go ahead and we'll notice it for that same time, but we may not be able to do it.
So currently, May 26th is set for now the motion to set aside default, the motion for a summary disposition and
Damages.
the damage. Okay. Thank you.
Thank you, Your Honor.
All right, thank you. All right, we will close this proceeding.